listen to what the Attorney General said, 2 points were outstanding. She said that there were discreet attempts to reach the court to explain serious matters of national security. What is discreet attempts? What the court makes out of those statements to leave it to the court. But from our side, we find it extremely deplorable for the office of the Attorney General will admit that there was interference in the judge and circumstances. We leave it at that. Number 2, the Honorable Attorney General.
My Lord, I wish to take objection. Kindly, I wish to take objection. That is a very major accusation. May please take your seat. That is very major accusation. And he has to put on record where I said that there was effort, or where I was admitting that the judge was interfered with as the Attorney General. And from my statement, where I admitted that there was interference with the judge.
Number 2, I'm old enough not to be distracted for my age. She has a written speech where she said there were discreet attempts to reach the court to explain the
But Lord, let him be given a dictionary to define the word attempt.
What do you there? No, I'm going to withdraw. We are on live camera. They will play that clip. She says she didn't say it. But I've finished what I was saying for issue number 1. Let me go to you can go back to your notes. She said they were discreet. Yes.
Attempts.
Yes. Yes. Inspect your office. So watacheza kwa citizen jioni.
Let him just apologize.
Okay, the court may not have had, but we had it. It's okay, my Lord. Could you allow me to go to number 2? I'm not apologizing, friends. The living was serious.
Since you are reading a statement,
Yes.
is it in your statement that you are making this attempts to approach from the court or something? What is it that you say so that you
My Lord, if they can make a copy, they can supply a copy to the court. What they are saying is to
My Lord, I said there were discreet
we have
attempts
a right to respond to the speech.
give information to the court on national security matter, and I stand by that because national security matters cannot be written and cannot be said in public. And if it is a matter of national security, all 3 arms of government collapse into one, and it can be relayed.
Here's a great one. You know, she was reading. I was listening.
It was an attempt, didn't it?
Yeah, it was an attempt. An attempt is as serious as a committed action. So, my Lord, permit me to finish. I'll be very short. Yes. So, the second fundamental issue I picked from previous speech, which she read, the submission, sorry, was that the heavy matters of national security demanded the presence of Mr. Gilbert Masengeli there, as opposed to what was otherwise personal tribulations that was to meet in court. And my lord, this background is important. It is important for this person. Lord, very early in the morning, we heard of reports published by none other than the President of the Law Society of Kenya, Madam Faith Odhiambo, the 3 petitions had been released and dumped somewhere. There is a background to it. Just be quick. Yes. If we just be patient and get to hear what I'm saying. So, my lord, it was our expectation today that the respondents will come and say, and we still expect them to say, that the first order for habeas corpus has been complied by us here before the court, Havi. Relax. And if at all they have complied with habeas corpus and produced the case, then this litigation will come to a natural end. So we'll be happy if we'll be told that is the case, because we're just saying this. Number 2, my lord, on the substance. Subsequent to the conviction and the sentence, Mr. Gilbert Masengeli approached the Court of Appeal on 2 civil applications. Yes, on 2, sorry, not civil, on 2 criminal applications. One is Nairobi criminal application number E466 of 2004. 466. My lord, if you could kindly ask them to be quiet, because I need to make this submission say quiet.
Is that making sense?
Yeah, it's not parliament or a public parliament. Yeah, the first is criminal application number E466 of 2024. This criminal application seeks in the main to stay the order convicting Gilbert Masengeli of contempt of court. Number 2, before the Court of Appeal, is criminal application number E471 of 2024. This second criminal application, Gilbert Masengeli and the rest of the team have sought an order before the Court of Appeal to suspend and stay the sentence made by this court upon conviction. My lord, indeed, these 2 applications were before the Court of Appeal yesterday. And they have been the Court of Appeal on Wednesday, the day before yesterday. And they have now been rescheduled for hearing next week, or a date that will be given by the President of the Court. So, my Lord, the derivative from the developments at the Court of Appeal others, that the Court of Appeal is now seized of the twin question of the conviction of Gilbert Masengeli and the sentencing of Gilbert Masengeli. And for that reason, Lord, the jurisdiction of this court can only await the Court of Appeal's decision on those two applications. Further, my Lord, those developments before the Court of Appeal have an impact on the suspended nature of the sentence this court meted for Gilbert Masengeli. The nature of that suspended sentence is therefore before the court. So, my Lord, with those circumstances, this court can only do two things. One is to hear from Gilbert Masengeli on how he has complied with the order for habeas corpus, because he's ill. And if he has complied, as we have read, then of necessity, these proceedings must terminate. Or if they don't terminate, then they must be held in abeyance, awaiting the outcome of the challenge against the order for conviction and the order of sentencing. That, my Lord, in my humble submission, is what should happen. I don't know whether any of my colleagues would like to speak. No.